A very warm greeting. This is Ishan Mishra as a host of Law and Life, present here with eminent senior advocate of Supreme Court of India, Sudh Markandeji. Today, our point of discussion is Shiv Sena Implosion in Maharashtra. Visuals of Inkambar Sindhe and his flock in Guwahati's Pose Hotel was a big surprise and a bit of shock to me. Their supposed leader, Uddhav Thackeray, had no clue about such a big revolt all these months and years. What lesson does it have for law and life?
First, let us take up the lessons of law. Uh, these are twofold. One is that breakaway group, that is Shinde group, though over three-fourths of the Shiv Sena legislature party will have to merge with some party in order to escape the disqualification under the 10th schedule of the constitution. I was surprised that except Aditya Thackeray, that is Chief Minister's son, there is no minister left with the with Uddhav Thackeray, the CM. This is very surprising. All the ministers have fled to Shinde group. The second is that in spite of such massive majority, they cannot be recognized as Shiv Sena legislature party in the Maharashtra Legislative Assembly because paragraph 3 of the 10th schedule dealing with immunity from disqualification on the basis of split of a political party has been omitted by the Constitution 91st Amendment Act 2003. Now let us look at how such is the result. The relevant provision in this regard are Article 191 Clause 2 read with 10th schedule of the Constitution. Originally, the provisions bearing on the disqualifications were contained in paragraphs 2, 3, and 4 of the 10th schedule. Paragraph 2 deals with the disqualification on the ground of defection. So, defection covers both, that is, split as well as merger. Paragraph 3, as it existed originally, provided that disqualification on the basis of defection will not apply in the case of a split of a legislature party. Paragraph 4 laid down that disqualification on the ground of defection will not apply in the case of merger of a legislature party with another party. Now, Law Commission in its 170th report submitted in 1999 had recommended the deletion of both the paragraphs, that is, paragraph 3 as well as paragraph 4. But in enacting the Constitution 91st Amendment Act in 2002, only para 3 was omitted, but para 4 has been retained. So what is the result? Result is that a split of a political party is no longer a ground of immunity from disqualification. That is, you will incur disqualification if even if there is a split. But merger with another party still continues to be the ground of immunity from disqualification.
So, what is the net result from it?
So the net result, as I perceive, is that in order to escape the disqualification under paragraph 4 of the 10th schedule, not less than two-thirds members of a political party, in the present case the Shinde faction, must merge with another political party. The other implication is that the remaining members of the legislature party, that is here the Chief Minister Uddhav Thackeray and whatever is left with him, whatever number of members have been left with him, have been reduced to a minority. But they are not subject to any disqualification.
Sir, an annihilation for life?
See, I'm not a political person. I may not be able to navigate through the political thicket. Still, what I can see from media reports is that in almost all dynastocratic parties, sycophancy and crony culture pervades. and the core cadre of such party is often neglected. Their grievances are hardly ever redressed. This is across the board. So, but it is they who have to operate at the grassroots level and answer ugly questions from the public. So, dynasts, compromise with the ideology of their party, as the father-son duo appears to have done in Maharashtra. In fact, ideology had rapidly eroded, uh, and therefore the grievances of the cadre remained unredressed for a long time and created an inner fury which imploded in the manner it did by the Shinde faction. So today I hear from the news channels and newspapers that the Shinde faction and the uh, 15 MLAs who have been disqualified by the deputy speaker have already gone to the Supreme Court and their matter will be heard today. In my humble view, time has now come for the Law Commission and the Election Commission to seriously address and eliminate the menace of not only the defections, but also greater menace, that is dynasticism, in the running of the political parties and the illicit exercise of political power. So this is my whole take.
Yes, and I hope in future we will get an affirmative response from the bodies and taking action. And that's all for the day. And thank you for watching. See you all in the next video. And thank you, sir.